Things are busy for the government at the moment. New ministers getting their feet under the table, new policies. But there are things that need to be done and they won't wait. Like sorting out what they plan to do after the Supreme Court ruling on deprivation of liberty. That judgment took away court oversight from we don't know how many people. The AGNI judgment, as it's called since the case was brought by the Attorney General for Northern Ireland, overturned the previous deprivation of liberty regime in an instant. It came out at the beginning of June 2026, effective immediately, and still nothing from government. Never mind nothing about what they're going to do about it, nothing signalling they know they need to do something. The minister responsible, Minister of State for Courts and Legal Services, has remained in post despite the wholesale changes in government. She'll be across her brief, but nothing so far. They're going to have to do something. Let me explain why. The previous test came from an earlier Supreme Court case called Cheshire West, because it involved Cheshire West and Chester Council. That ruling set out something called the acid test, which was straightforward. It didn't matter what your individual circumstances were. If you were living in conditions where your liberty was restricted, in summary where you couldn't do what you liked when you liked, then your liberty was being deprived and that needed authorising by the state. From June 2026, it's all changed. That was the wrong test. The Supreme Court said the correct test is multifactorial, deriving from European cases and balancing a variety of things like consent, non-objection, how far from conditions like a prison cell the person is living under, what is restricted, how it affects them, how it relates to delivery of care. It's a lot less clear, a lot more nuanced, a lot fuzzier, and importantly, requires a lot of interpretation. I've already seen a wide range of interpretation and approaches to this new test and been part of quite a bit of disagreement. The key thing is many fewer people are going to be considered to be deprived of liberty under the new AGNI test. And that is a problem for government, because rights are rights, rights remain. Before it was the courts which did all the running, all the work, because everyone being restricted was caught up in the court-run system, not now. And that creates a gap, an oversight gap, a rights gap, the AGNI gap. And it's government which must step in to fill that. Let me explain why. Someone is in a care home. Previously, as I said, whatever their personal circumstances, if there were restrictions in place, the court had oversight. Full stop. Not anymore. Now someone, usually from a local authority, will consider both the restrictions and the person being restricted. And if they decide there's no deprivation of liberty, that's it. For example, someone might be in a care home in an advanced state of dementia and compliant, acquiescent, or apparently consenting to being stuck in a room, not able to get out. Or someone might be cared for by family members with significant restrictions in place, but it appears to the assessor the restrictions are in place for delivery of care and there's no deprivation of liberty. That's it, job done. The court is not there anymore to say, hang on, just wait a minute. The old regime of authorisation of community deprivation of liberty also had an inbuilt safeguard in the form of something called a Rule 1.2 representative, an advocate to report to the court and make sure that someone vulnerable, deprived of their liberty, was not having their rights improperly infringed. Not anymore. Rights restricted, but no deprivation of liberty, no court oversight, no advocate. That's why a group of social care lawyers are desperately trying to compile lists of people previously considered to be deprived of liberty who no longer are, so those people don't disappear, so their rights are not forgotten. But it's not lawyers' job to try to do that. It's the government's. And they really have to. Because if they don't, they'll be breaching their own commitments to the European Convention of Human Rights. Under that convention, if someone brings a case, they bring it against the government, because the government has allowed a situation to exist where fundamental rights are breached, and the government is expected, required, to fix it and make sure those rights are upheld. And that is what is going to happen in this case, unless the government fixes it very soon or sets out how it is going to. They are going to be taken to the European Court. A test case will be brought. Crowdfunding might raise the money. Organisations would sponsor it. Someone no longer entitled to safeguards will have a case brought in their name, and the government will have to account for the loss of rights. And in my view, then they'll have to fix it. And in the meantime, there will be headline after headline about how this government is being taken to court for failing the most vulnerable in society, which is not a good look for a government. But Minister, I do have a suggestion for you. It might solve your problems for less than the cost saved from shrinkage in the previous system. Set up an Office for Deprivation of Liberty review. You can find room for it in the department. It won't need a big staff. All deprivation of liberty assessments must be lodged with this office, which will review the assessment. They will then have the power to remit the decision back to the assessing body for reassessment if they consider it necessary. If they are not happy with the reassessment or for any other reason, they can refer the question to the Court of Protection. That's it. Those are the powers. Review, remit, refer. An office of not many people with limited powers, costing less than is saved by the reduction in work from the changes. But it would bridge the AGNI gap. It would protect the vulnerable and constrained. And it would also protect the government from all the really awful publicity that is surely coming their way if they don't do something to ensure that the most vulnerable people remain protected. That's it for this video commenting on the AGNI gap. I'm Sam Green. Subscribe or look out for more videos from Court of Protection Briefs.